You swear again.
Sorry.
You swear again.
Sorry.
You swear again.
I'm
You're going to
sorry.
be in contempt of court and you're going to go to jail.
Okay.
This is file number 205282DC. The matter is captioned Murphy versus Murray. There is a pretty significant history in this case, and the court will set it up. Entered an order back on September 9th of the year 2024, holding all of Mr. Murphy's parenting time in abeyance. Following year, in July of 2025, filed a motion asking the court to give him another chance and start parenting time anew. The court thought that, well, you know, it's always good to give somebody a chance. If kids can have their father in their lives safely, then they should. So I referred the matter to our referee to litigate the issue and see whether or not it's in the best interest of the minor children that their dad be back in their lives. The parties came to an agreement on September 30th of the year 2025, and they placed their agreement on the record. Attorney Wood prepared an order, but Mr. Murphy wouldn't sign it. And it went a really long time with no activity on the file because Mr. Murphy wouldn't sign the order. In fact, Attorney Wood had to, you can shake your head all you want, but I'm going to get this out. You're going to have a chance to respond, but right now I'd like you to just sit there and listen, please. Okay. In fact, Mr. Murphy had to file a motion and ask the court to enter the order because Mr. Murphy wouldn't sign it. April of this year that the court was able to enter that order, which set up a framework of what Mr. Murphy was supposed to do before he could resume parenting time. He was supposed to submit to a counselor. He was supposed to submit to alcohol and drug testing, actually a drug and alcohol assessment. There were just a lot of steps that the parties agreed Mr. Murphy would have to take before he'd be reunited with his children. But we lost a lot of that time because the order wasn't entered from September until April. Mr. Murphy was attempting to contact one of the children through school, called the school and said, I need to talk to my daughter, have her come down to the office. And one of the school personnel, teacher, principal, or whomever, called Ms. Murray and says, hey, is this supposed to happen? And so Ms. Murray was very concerned about this attempt at contact, asked the court to enter an order preventing Mr. Murphy from contacting the children in school, which the court did. It did sign the order. But
I'm sorry, but I haven't seen my kids in 5 years. I don't even know what.
Whose fault is that?
Not all mine.
That's your fault. It absolutely is your fault.
No, it's not.
Do you want to have a hearing or do you want to argue?
I want to see my kid.
Do you want to have a hearing or do you want to argue?
We can have a hearing. I want to see my kid.
Are you sure we can have a hearing? Because I'd like to get through this.
I have no control. You're in control of everything. All you guys are.
Really? Meet me at the podium. Please raise your right hand. You promise that you will tell the truth, the whole truth, nothing but the truth, so help you God.
You have no choice, yes.
Do you, yes or no?
Yes.
All right, let me ask you a couple questions. Let's see who has control. Have you located and set up counseling with a reunification counselor?
I didn't agree to
Did you or didn't you?
No. I don't have insurance.
Did you or didn't you
Laid off from my job.
A recommended treatment and services following a prevention and treatment services through PATS? Yes or no?
No, but I've done a bunch of that through my probation.
You may have a seat. You didn't do either of those things that you said you were going to do to be able to see your children.
Yes, sir.
That's on you.
Yes, sir.
The court signed the order. Mr. Wood, come on up and give me your argument as to why that order ought to continue.
Well, Your Honor, thank you. The reason we'd like it to continue is that the agreement kind of implies that the contact that will be established between dad and the children would happen through the reunification counselor and making sure dad is taking care of some of the treatments from some of the things that were related to his past use of alcohol and drugs, and then keep the children safe. Being able to go to the school to either speak to the children or potentially remove the children from the school would kind of thwart the purpose of that order. I've attempted to try to talk to Mr. Murphy about this, but he refuses to have any real discussions. He claims he's at a different address and refuses to tell me what his current address is. So we're just concerned that he's going to try to use the ability to access the school, and the school has made it clear to my client, and her understanding is that unless there's a court order that says that dad can't take the kids from these places, they're not in a position to stop them. or if he can't have the contact with them at these places, they're not in a position without a clear order to say so. So we would like the order to continue just so that it kind of fits with the order that was agreed to between the parties and follow through with that process. And then as that goes through, we can readdress this issue.
Very good, Mr. Wood. Thank you. Mr. Murphy, this is your opportunity to respond to Mr. Wood's argument. I'll need you at the podium if you care to respond.
Can I ask, like, what I did to my kids to not be able to see them? What have I done to my children? Because a relationship there failed. I was a drunk piece of shit. I'm sorry for cussing for a long time. But I changed. I went and got sober. I haven't seen my kids in 5 years. They cut off all contact, phones, everything. I want to see my kids. What's wrong with me calling? I have a recording of me calling. I didn't do anything wrong. I called and asked for my daughter to have my phone number. They took all contact with my children. It's been 5 years. I want to see my kids, sir, please. That's all I want to do. I want to see them and I'll walk away. I'll never bug this lady again. I want to know they're safe. I haven't seen them in 5 fucking years.
You swear again.
Sorry.
You swear again.
Sorry.
You swear again.
I'm
you're going to
sorry.
be in contempt of court and you're going to go to jail.
Okay.
Okay? This court has given you respect. It asks for the same in return from you.
Being on my mother's floor.
Have you said everything you wanted to say regarding this issue?
Yep.
Have a seat. The court ceased parenting time between Mr. Murphy and his children because it made a finding that continued contact clearly and convincingly convinced the court that contact would emotionally or psychologically harm the children. It really tried to break towards family reunification when it allowed Mr. Murphy's second motion or his motion to reintegrate with his children. But it seems like that was a mistake because of Mr. Murphy's behavior in the courtroom and his inability to follow orders. So here's the order moving forward and his inability to do anything that he agreed to do back in September, starting with agreeing to enter the order, which would set up the framework for him to see his children. Mr. Murphy complains that he hasn't seen his children, but the reason why he hasn't been able to see them is all of his doing. Number one, drugs and alcohol, domestic violence. Number two, he won't do the work that he needs to do to reunify. And until he does that work to reunify, he will not see the children, not under my watch. You absolutely will not. So you need counseling, you need substance abuse treatment, and until those things are done, you will not see those children. In fact, the order moving forward today is that there's no direct or indirect contact between Mr. Murphy and his children, and there will be absolutely no contact, direct or indirect, until this court orders it. So that amends the order from the referee, Mr. Wood. The counselor does not have the authority to start parenting time. That won't happen until this court approves it. That's the order of the court. I'll take care of that. We are all set and in recess.
Thank you, Your Honor.
This emotional family courtroom hearing centered on a father desperately asking to reconnect with his children after years without contact. However, instead of convincing the judge that he had changed, his behavior inside the courtroom reinforced the very concerns that had kept him away from his children in the first place. By the end of the hearing, the judge concluded that the father had ignored every opportunity to reunify with his family and ruled that he would continue to have no contact whatsoever with his children until he proved he could follow the court's orders. The hearing began with the judge reviewing the lengthy history of the custody case between Murphy and Murray. Several years earlier, the court had suspended all of Mr. Murphy's parenting time after determining that continued contact would likely cause emotional or psychological harm to the children. Although the decision was difficult, the court believed it was necessary to protect the children's well-being. About a year later, Murphy returned to court asking for another opportunity to rebuild his relationship with his children. The judge explained that courts generally believe children benefit from having both parents involved in their lives whenever it can be done safely. Hoping that Murphy had changed, the court referred the matter to a referee so both sides could develop a structured reunification plan. Eventually, both parents reached an agreement outlining exactly what Murphy needed to accomplish before seeing his children again. However, the plan immediately ran into problems. The judge explained that after the agreement was reached, Murphy refused to sign the court order that officially put the reunification plan into effect. because of his refusal. Months passed without any progress, while attorneys were forced to return to court simply to finalize paperwork that Murphy had already agreed to. By the time the order was finally entered, valuable time had already been lost. The reunification plan required Murphy to complete several important steps before any contact with the children could resume. He needed to participate in counseling with a reunification specialist, complete drug and alcohol assessments, follow any recommended treatment programs, and demonstrate that he could safely return to the children's lives. Instead of completing those requirements, Murphy attempted to contact one of his children directly through the child's school. According to the judge, Murphy called the school and asked staff members to bring his daughter to the office so he could speak with her. School officials immediately those children first. For Mr. Murphy, the path to seeing his children still existed, but only after proving through consistent actions, not emotional promises, that he was capable of putting their safety and well-being above everything else.